All right, good morning, everyone. Thank you for coming. Good morning to everybody on the live stream, and hello to everyone who will watch this sometime in late December in a mad rush to finish their CLE credits. Happy holidays to you all. This is the Lewis C. Greenwood lecture series for Case Western Reserve University School of Law downtown at the City Club. My name is Andy Geronimo. Our topic this morning is internet free speech. You know, the internet is a strange place. It's interesting that we've arrived at this moment in the internet. Those of us who have grown up with the internet and seen its evolution realize how strange of a time we're in and how odd the structures that have built around it are. So much of our lives are lived on the internet. Our social lives, our political lives, certainly our work are all on our internet. Our activities as consumers and other things certainly are governed by the internet. We're going to talk about some constitutional concerns that are raised by the internet. That will be a relatively short portion of this talk. The questions, I think, were a little bit more interesting before some recent case law developments. This is an area that's moving extremely fast. When I proposed this topic, the constitutional concerns were a little less settled, and we'll talk about a Supreme Court decision this summer that dealt with some of those issues, but also the talk about intermediary liability and Communications Decency Act Section 230, which governs private entities online, has been sort of a hot topic lately. And actually, if you're interested, if you're so enthralled by this section of the Communications Decency Act, immediately after we finish up here at 10 a.m., the House, I think it's the Energy Committee, will be hosting a hearing on whether or not to alter the statutory text that we are going to be discussing here. I've left some handouts there that have sort of the relevant portions of the statutory text. It'll be relatively important, at least to understanding some portions of this talk, so I figured rather than having you read off of the slides, I would give you the text. On the reverse of that are some interesting articles and other resources where you can read more, both on the pro Section 230 anti-liability for intermediary side and on the pro-regulation side. I'll just say that I have a varied practice in my career right now. I work in the clinic at Case Western Reserve University School of Law. I teach in the IP Venture Clinic. We mostly advise startups on company formation issues, intellectual property issues, but also some liability assessment. And Section 230 is certainly a key statute that our clients who own websites or apps or other internet services rely upon to really have a predictable level of liability in their businesses. I also consider myself a civil liberties lawyer. In the past, prior to the IP Venture Clinic, I taught the First Amendment Clinic and also a First Amendment lab. I've litigated some of the issues that we'll talk about in these cases. And I should also say that I'll try to be as accurate and straightforward as possible. There's a lot of bad information out here about these regulations and about these laws, a lot of politically motivated discussions about these types of things. I'll try to be objective. I will say I'm a dues-paying member of the Electronic Frontier Foundation, which has filed amicus briefs in nearly all of the cases that we will discuss here. You may see my name on amicus briefs filed by the Electronic Frontier Foundation. Also, as a free speech lawyer, it's sort of it could inure me to one side of these discussions or the other. I want to put that out there, but I think it's really important. I'm not going to make any new normative ground. I'm not proposing any new policy issues. We'll talk about policy changes that have been proposed, legislation that's been proposed. But really, if I can merely describe accurately the state of the law right now, I'll be happy with that. So talking about our lives on the internet, Facebook now has billions of users. So it's estimated that a quarter of the world's population is on Facebook at least monthly. So that's 2.4 billion monthly active users worldwide. 84% of adults aged 25 to 29. I don't know if we have any of those in here, but they're extremely active on Facebook, and 79% of US adults aged 30 to 49. Just goes to show how much of our lives now are active on Facebook. And certainly if any of you are all on Facebook, I am on Facebook, but I'm not very active on it. I certainly have friends and neighbors who are extremely active, so if you think about the number of users compounded with the number of posts, you'll see why it gets relatively complicated to moderate the kind of content we're talking about here. Increasingly, Facebook is becoming a political animal. So in political dialogue these days, we're talking about disinformation on Facebook, how Facebook's algorithms are directing political speech, and some debates around that. Obviously, we have a Twitter presidency here now, where the President of the United States has 50 million Twitter followers, and in a recent case brought by the Knight First Amendment Institute at Columbia University, challenging the blocking of certain users from the president's and nominatively private Facebook account that was later found to be a public forum. They talk about the importance of the president's Twitter account to announce, describe, and defend his policies, to promote his administration's legislative agenda, to announce official decisions, to engage with foreign political leaders. All of these things that we think about as traditional governmental functions are part of the reason that the Second Circuit Court of Appeals found that it was a public forum for the purposes of First Amendment law. In addition to the political dialogue that we have on these internet sites, we are also seeing an increase in online extremism. So this is sort of a blurring of the lines between speech and conduct that in the early ages of the internet we thought was sort of a distant possibility. So, you know, in the early stages of the internet, when it was bulletin boards and opinions on, you know, whether it's journalism or cooking or sports or rock bands or whatever it is, I don't think it was necessarily contemplated that the reach of these social media sites would get to the point where the prospect of going viral with some really terrible, tragic event would be a driver of some of this extremism. Examples are the Tree of Life synagogue shooting in Pittsburgh, where the shooter had a long history of anti-Semitic posts on some far-right, sort of marginalized social media networks, in particular Gab, and also the Christchurch, New Zealand shooting, which I actually did a little bit of media around talking about these content moderation policies, where the shooter sort of announced his plans on some of these marginalized sites that are targeted to specific political views, but also live streamed the event on Facebook. There was a lot of criticism on Facebook on their in what some would say inaction, but their failure to get that video off of the internet sort of expeditiously. In some media, YouTube's chief product officer said that that Christchurch shooting was a tragedy designed with the purpose of going viral. Shows the way that these internet platforms and the reach that they have can affect some conduct. And actually, speaking about the importance of social media to our lives, in 2017, the Supreme Court evaluated a ban that North Carolina had passed on registered sex offenders on Facebook. So the Supreme Court, in a unanimous decision, said that foreclosing access to social media altogether prevents the user from engaging in legitimate exercise of First Amendment rights. And as a basis of that decision, they say that for many, social media is a primary way that we know current events, that we check ads for employment, that we speak and listen in the modern public square, and otherwise explore the vast realms of human thought and knowledge. It's thought that Facebook is sort of this modern town square, and we'll talk about that and whether that has constitutional implications. And here's where we're talking. So constitutional concerns, this should be fairly quick. I've had to call this down, arguments on both sides because of some recent decisions, but we can run through it relatively quickly. Again, this is the Knight Institute versus Trump lawsuit that I talked about that started in the Southern District of New York and eventually made it to the Second Circuit. These were users on Twitter a social media platform who had been blocked by the president. The president said that, I've got my professional account and I've also got my individual account, and all of these users that I've blocked are from my individual account. So he had this account well before he was in the political sphere. This was his personal account, but the Second Circuit and really the Southern District of New York didn't stop there. What they wanted to do was really determine whether or not the president had opened up his online platform as a public forum for the purposes of free speech. They found that it did. The Second Circuit did, and they said the First Amendment does not permit a public official who utilizes a social media account for all manner of official purposes to exclude persons from otherwise open online dialogue because they expressed views with which the official disagrees. So there are ways in which the Constitution and First Amendment can be implicated online, but it's not necessarily in the ways that some folks have posited, specifically some members of Congress that we'll look at in a little bit.
Has it been appealed to the Supreme Court?
I don't know. I know this decision. I don't know that answer. I think that it has, and I think that cert has been denied. But I'm not positive about that. I could check. So one thing that you see, and certainly from prominent politicians out here, is trying to make this constitutional argument that Facebook is the new public square. Folks that make this argument are primarily relying on a series of really actually old cases. Some of you may remember from constitutional law, Marsh versus Alabama. This is the company town case where a private company had a town with a post office, streets, sidewalks, and were tried to prohibit a Jehovah's Witness from passing out leaflets. When they arrested her for trespass, the town said, we are not a state actor for the purposes of the First Amendment. We can do whatever we want. This is private property. The Supreme Court said the more an owner opens up and performs a traditional public function that can transform a nominatively private actor into a state actor for purposes of First Amendment analysis, and it's really a threshold question, so it becomes, it gets you into that scrutiny analysis of whether these regulations need to be governed by the First Amendment. This was a common argument saying that Facebook is the new public square. As much as private entities had company towns, now in the modern era, we have all these billions of users worldwide. We have political activity going on all the time. It's really the new shopping center or public square. These arguments were largely debunked in a case this summer called Manhattan Community Access Corp. Versus Halleck. In this case, the New York government had granted a nonprofit the ability to operate a public access channel, and the challenge to decision making on that channel led somebody to challenge that they were being discriminated because of their viewpoint. The Supreme Court, actually in a 5-4 decision authored by Justice Kavanaugh, said that merely hosting speech by others is not a traditional exclusive public function and does not alone transform private entities into state actors subject to First Amendment constraints. This decision, in many people's mind, I've heard it described as the nail in the coffin for this theory that's been advanced by some, that Facebook is a state actor and should be regulated as such. So setting the constitutional concerns aside, we're going to talk a little bit about intermediary liability, and really that's because all of this activity on the internet is largely driven by public companies. So you've got Facebook, you've got Twitter, Instagram, YouTube, Google, and all these other social media platforms that have all these users, and the question is whether we can hold those platforms or those online publishers liable for the content that their users post. All of these platforms are really driven by user content, so Facebook, YouTube, Twitter don't really publish content of their own. They allow people to open accounts that allow those folks to publish their own thoughts and feelings. This is the hearing that I mentioned. It starts in about couple hours, and some of the scholars that we'll cite here for some of the legislative proposals will be speaking at this. I just added this slide last night when it was announced. There's a memo to Congress on this House Committee on Energy and Commerce's website, sort of laying out the problems of what we'll talk about with this Communications Decency Act, Section 230, again, which you have in hard form in relevant part on your tables. So this is a part of a Senate hearing where Mark Zuckerberg, the founder of Facebook, was hailed before the Senate and questioned about Facebook's policies regarding speech. I'll lead off by saying that what Senator Cruz says here has no basis in law and is a totally inaccurate summary of the law here, and we'll get into that, and you can follow along if you like.
Thank you, Mr. Chairman. Mr. Zuckerberg, welcome. Thank you for being here. Mr. Zuckerberg, does Facebook consider itself a neutral public forum?
Senator, we consider ourselves to be a platform for all ideas.
Let me ask the question again. Does Facebook consider itself to be a neutral public forum? And representatives of your company have given conflicting answers on this. Are you a First Amendment speaker expressing your views, or are you a neutral public forum allowing everyone to speak?
Senator, here's how we think about this.
Let's see if I can get this to not skip all around.
I don't believe that there is certain content that clearly we do not allow. Right? Hate speech, terrorist content, nudity, anything that makes people feel unsafe in the community. From that perspective, that's why we generally try to refer to what we do as a platform for all ideas.
Just because the time is
I'm sorry about this. Hopefully we can get the key line here.
Constraint. It's just a simple question. The predicate for Section 230 immunity under the CDA is that you are a neutral public forum. Do you consider yourself a neutral public forum, or are you engaged in political speech, which is your right under the First Amendment?
Well,
okay. I'm sorry about that, but that is what Senator Cruz says there is basically Facebook has a choice. They're either a neutral public forum, in which case they would not be seen as the speaker of content their users post, and they sort of let all speakers through, or they're a political actor with their own First Amendment rights, making publication decisions, and those decisions would lend to the view that Facebook itself is a publisher of those decisions. Senator Cruz describes this as a predicate for immunity that Section 230 offers. I'll pose to you that that's nowhere in the text of Section 230 and nowhere in the judicial decisions. So what Section 230 really says, and I should start by Section 230 is part of a law called the Communications Decency Act. It was enacted in 1996, and it was really, the main purpose of it was to regulate the provision of indecent materials, which is to say pornography, to children. It was a large part of the law was struck down in a case called Reno versus ACLU on overbreadth and vagueness First Amendment grounds, but along with the Communications Decency Act was this immunity for interactive computer services that survived the decision of that lawsuit. So what Section 230 says is that, and these have been described as, quote, the 26 words that created the internet. It says no provider of or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Which is to say that when I get on Facebook, and if I were to defame somebody, if I were to say, my friend Adam is a criminal and a felon, Adam could hold me liable for that, but he could not hold Facebook liable for that. And as a basis for this liability, what the folks who proposed this law were mostly concerned about is that internet companies regulate themselves. So the subsection is entitled Protection for Good Samaritan Blocking and Screening of Offensive Material, and the predicate for that liability, and it's not really a predicate, it's really it goes hand in hand with that liability. It says that any action voluntarily taken in good faith to restrict access or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. So you can't, in summary, you can't hold interactive computer services liable for third-party content, and at the same time, you can't hold them liable for removing user content to meet their standards as set by the relevant community. So we're taking that constitutionally protected speech out of the considerations of when somebody deletes, or one of these interactive computer services deletes somebody's post. They don't have to run through a rigorous First Amendment analysis to determine whether or not Adam's claim about me is defamation or whether it's protected speech. They can delete it and not worry about it because of their community standards. This is a broad grant of immunity. So if you think about it, really a newspaper or otherwise not online publisher, if they were to publish something that was illegal, whether defamatory or otherwise, they would be held responsible. And the question is, why is the internet different? And the basis for passing the Communications Decency Act was really the idea that the internet was different. So we'll do a little bit of history. We'll go back to 1959, a case called Smith versus California, in which someone was convicted of a Los Angeles ordinance for possessing obscene materials. So you weren't basically hardcore pornography. You were not supposed to possess these things in a bookshop. And a bookseller was convicted under this statute. Upon review, the Supreme Court held that it was unconstitutional to hold sort of a passive distributor of these things liable for the contents of everything that they pervade. So if you think about it, a bookseller or somebody at a magazine stand doesn't really have the opportunity to review everything that they have. A bookseller isn't sitting there reading every book, scanning it for defamatory or otherwise illegal material prior to selling it. If you were to hold those booksellers liable for that without some knowledge of the illegal content, it would chill speech. So the idea would be we wouldn't have booksellers if we impose this liability on them to affirmatively review everything that they sell. And along with Smith versus California is the idea that if they do have knowledge of something, they would be liable. So if they were put on affirmative notice that one of their books contains something illegal, that it may be proper to hold them liable. The Supreme Court in Smith, California, didn't really opine on what specific scienter requirement there would be, but they said some knowledge of illegal content is required. You can't just say the fact that it's obscene and the fact that it's in your bookshop is enough to hold this essentially intermediary liable. And then with the dawn of the internet, we get into these series of cases where courts are struggling with the idea of applying this intermediary liability to these new forums that have been created by the internet. So there's a case called Cubby versus CompuServe, where a publisher of basically an early blog sued the publisher of a competing blog that he alleged was defamatory, but also CompuServe, the company that hosted the bulletin boards, on a defamation claim. And the court in the Southern District of New York found that CompuServe itself was not liable for the defamatory content because it didn't have editorial control over that publication, and it harkened back to Smith and said that it has no more control over the publication of that content than does a public library or a bookstore or a newsstand, and it's not feasible for CompuServe to review absolutely everything that its users post. So at this time it had dozens, maybe 100 bulletin boards, and while CompuServe granted folks access to publish on those boards, what they weren't doing was reviewing everything that was published there. Following Cubby, there is a case that actually is explicitly the driving force between Communications Decency Act Section 230. It's called Stratton Oakmont versus Prodigy Services Company. Stratton Oakmont is the securities brokerage firm that was featured in the Wolf of Wall Street movie, if you all are familiar with it. And what Stratton Oakmont said is that on a Money Talk bulletin board, somebody posted allegedly defamatory content saying that Stratton Oakmont were crooks and they were running a scheme and all these defamatory things. The difference between Prodigy and CompuServe, though, is Prodigy had a number of filters. So Prodigy would filter your post if it had it had foul language in it, if there was obscenity, if there was nudity, they would take it down. Basically, the Prodigy was held liable for publishing this because it was taking some affirmative steps to exercise editorial control of what was contained on its site. So the fact that they screened some material lent them to some liability for the otherwise illegal material. It really created a sort of a perverse catch-22 that Section 230 was designed to solve. As an internet provider, you either do no moderation whatsoever, and your site becomes sort of a hellscape of trolls and other folks really ruining the dialogue for other people, or you don't allow any content whatsoever for fear that you'll be held liable for it. The key question in some of these cases is whether you're an affirmative publisher, whether you're like the New York Times and you review everything and you've cleared it of all defamatory statements through pre-publication review and those types of things, in which case you'd be liable, or are you just a passive conduit? Are you the bookseller, offering everything that you can think your customers want, in which case you may not be liable. The Stratton Oakmont decision really caused a rift and really caused a lot of these early internet startups to worry significantly about their business models. If they policed content at all, they could be held liable for any illegal content on there. And when you think about sort of the scale of these things and the amount of posts that might be on a bulletin board such as this, even in 1995, you start to realize how untenable this might be under, I assume we're all lawyers here, under the threat of litigation and even nuisance settlements and those types of things for the allegedly defamatory content or otherwise illegal content on those sites. So Section 230 was, in essence, a hope to balance some competing interests, the competing interest of free speech, that is, not being excessively heavy with moderation so that we can, let people realize the full value of the internet, let people spread their ideas far and wide, the competing interest of online innovation, something about what I was talking to with my startup clients who, could allow zero user content if they had this fear that they would be held liable for any illegal content that their users post, and also encouraging these sites to engage in responsible content moderation without seeing threat of a lawsuit on the backside for saying, this was constitutionally protected speech that you took down, and it was, somehow illegal under a state action doctrine for you to take that down. And what we really get into is the question of internet exceptionalism and whether the internet truly is different for this analysis. I'm going to try and play this video. This is John Perry Barlow from a talk he wrote actually when the Communications Decency Act was passed, and this was really as to the regulations that Congress had passed on that the parts that were later struck down in the Reno case. I'm going to try and play this. If it doesn't work, I'll just try to summarize what he said.
Governments of the industrial world, you weary giants of flesh and steel, I come from cyberspace, the new home of mind. On behalf of the future, I ask you of the past to leave us alone.
So that's just the intro. It's funny. It's sort of ironic to me. This is really what the internet was like in the early days, with the stuttering video and the, you'd try to talk about something and you'd wait around for it to complete. But really, what what Barlow is saying there is that the internet is different. There is no physical space in which to regulate. So, there are networked servers in certain areas, but there are certainly complicated jurisdictional questions about how to regulate somebody's speech on the internet. There are also, the possibility of truly anonymous talks on the internet. The internet basically posed new problems for government regulation. Which governments should regulate these? How do we identify those folks? And those types of questions. Coming out of the passage of Section 230, we had some relatively broad judicial interpretations of 230 where it was essentially immunity from liability for anything a user posts. And again, this is the text of it. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by basically another user. So one of the first cases, and I actually think it was the first case to examine immunity under Section 230, is a case called Zarin versus America Online. If you remember AOL, it was the way that many of us got on the internet in the 90s. You would pay by the minute. The video would stutter and skip like it was here. And really, they had a relatively curated experience. This is a bad picture of the post that's in question, but what somebody did is somebody used Mr. Zarin's identity and his phone number, said, and this was immediately in the wake of the Oklahoma City bombing. This person said, I'm Ken Zarin, I'm selling these t-shirts. These t-shirts say things like, shit happens to explode in Oklahoma 1995. Horribly offensive shirts. So another one is, visit Oklahoma, it's a blast. If you want to buy this t-shirt, here's my phone number, call me. If it's busy, call back. This was not Ken Zarin who posted it. This is somebody who posted it using his name. Ken Zarin starts to get phone calls all the time. He doesn't know how to manage it. He doesn't know where it came from. Eventually realizes that it was broadcast, one, on the radio, and two, through a post on America Online. Zarin writes to America Online and says, you need to take this down. People are calling me all the time. This is not me. I don't know what to tell you, but take this down. For a long time, AOL refused to take this down and said, we're not liable for this speech. This is purely user content. And the Fourth Circuit, upon review, said that Congress made a policy choice. They're not going to deter, they're not going to propose that these platforms be liable for this speech. And really, if you want to go after somebody, Ken Zarin needs to find who posted this and go after that person. So notwithstanding that the person who posted this might be liable for false light or some other state law defamation claim or other claim, you could not hold America Online as the publisher of this because of the text of Section 230. Again, it was one of the first courts to interpret 230, and folks were in the tech industry. If you read some of the literature on it, folks were unsure of exactly how broad the text of 230 would be read, and the Fourth Circuit's decision in Zarin seemed to imply to them that it would be read extremely broadly and protect them from, even horrible instances, cases with horrible facts. Another case out of the Ninth Circuit in 2003 was a case called Batzel versus Smith. Ms. Batzel was a lawyer, an art lawyer, and she had a disagreement with a contractor at her home. The contractor got online, said, I've been in Ms. Batzel's house. I think she's a descendant of a Nazi. I think it was Himmler, and I think that she has a lot of questionable art in her house. So the implication is, she's the descendant of Nazis, and she has stolen art within her house. In this case, Ms. Batzel tried to get these, and actually this case is notable because this allegation was emailed to a very small listserv. It was called the Museum Services Network, I believe. It was a listserv distribution to essentially 100 people, and the court found that distributor of that was not liable for publishing this because it was another user who originated this content. There was some thought that Section 230 would only be applied to larger platforms, and this really, in the Ninth Circuit, sort of again broadened that to encompass not only these large platforms, but the smaller ones as well. So coming out of those broad interpretations where these internet sites were fairly confident that they could publish any user content without any regard to whether it was illegal or not, and also they could moderate content without any regard to whether it was constitutionally protected or not, we get to see some narrowing of judicial interpretations of Section 230. And a lot of this narrowing comes from the definitions. So also on your handout, there's a definition of what do we mean by information content provider. You know, I'm on the internet all the time. I look at this statute all the time, and I still stumble over the phrase information content provider. I even did it there. It's not immediately clear what that means to basically anybody, but what the statute says is that an information content provider is somebody that is responsible in whole or in part for the creation or development of information provided through the internet or any other interactive computer service. Many of the cases in the narrowing of Section 230 have to do with the terms responsible and development. And really what those terms mean. Sort of the seminal case on Section 230 is a case out of the Ninth Circuit, commonly referred to as roommates.com. Roommates.com was a site that would match you up with potential roommates. And they were sued for violations of California's Fair Housing Act because they said that it basically enabled folks to violate California's Fair Housing Act. And they did this basically when you would sign on to roommates.com. There were a series of drop-down menus about you and about the roommate you were seeking, and then there was an open area where you could put exactly what you were looking for in a roommate, and then the design of the site would allow you to search for potential roommates. This was challenged under fair housing laws, saying that, you know, if I get on roommates.com and I say, you know, I only want a straight white female roommate, that's a violation of these fair housing laws. It's actually a very interesting opinion. There's an en banc opinion, actually authored by Judge Kaczynski, formerly of the Ninth Circuit, evaluating exactly how liability attaches to each of these functions. That is, the drop-down menus that basically require you to identify your race and the races of your preferred roommates, but also the open-ended narrative portion where you can say this is what my ideal roommate looks like, and then finally the search function where it basically enables you to find, use these queries to find your ideal roommate. Ninth Circuit said that roommates.com was not immune under Section 230 for the times in which it required users to express an illegal preference. So there were no options as a requirement of the site. You had to give this site your race and the race of your preferred roommate by giving basically its users no choice whether or not to violate these fair housing laws. It was not entitled to Section 230 immunity because, as the decision says, basically roommates.com was a co-developer of this. So it's not just that the users expressed an illegal preference, is that the site required its users to express an illegal preference. On the other hand, the open narrative portion, if a user just says, you know, I'm you know, racist, sexist, homophobic, and all I want is this type of roommate, in that case, roommates.com did not force its users to make that discriminatory choice, and the court said that they would not be liable for that sort of open-ended narrative portion, but nonetheless, when they did co-develop the content, they were responsible for that. Another area where Section 230 has been narrowed, which involves some, I'll admit, some artful pleading on behalf of some of the plaintiffs' lawyers, what happens when you're trying to hold a website liable under a theory other than it is a publisher or a speaker of content. So defamation and intermediary publication. Certainly there's a wealth of law where you are the publisher or speaker of those things, and as the publisher, you take on the role as speaker. These cases generally fall in the lines of negligence or other tort theories where it doesn't matter whether or not somebody is the speaker. So a case under this is Barnes versus Yahoo. This was a promissory estoppel theory. in Barnes. Barnes's ex-boyfriend had a fake profile, basically soliciting suitors, to put it mildly, to contact Miss Barnes. Miss Barnes, it's sort of similar to the Zarin case, where it's somebody creating a fake profile on an online platform. But in this case, there was no liability for Yahoo, because when Miss Barnes complained to Yahoo, they promised her they would take it down. She relied on that promise. I think by stopping publicizing this horrible content, she passed up some news opportunities, and that Yahoo's promise and their breach of that promise and her detrimental reliance on that, the contents of that promise, the Ninth Circuit said that was, not treating Yahoo as the publisher or speaker of this content. They weren't forced to make this promise to her. They held that for a promissory estoppel claim that Yahoo was not immune from lawsuit under Section 230. So, in essence, boiling it down, courts have limited the immunity granted to these internet websites when the site either contributed to the illegal content, as in the roommate's case, and there's another case called AccuSearch that isn't up here, but it's a similar thing. If you, basically, it's an incitement theory. If you encourage, or it's not even encourage, if you require your users to post illegal content, there's no immunity there. Or if you can sue for something that is based on something other than publishing or speaking. And then with the ebb and flow of things, some of these artful, as I've called them, pleadings have been struck down. So we'll get into what I'll call modern era 230 cases. Excuse me. This is a case out of the Sixth Circuit. It's called Jones versus Dirty World. The Dirty is a gossip site, and it basically asks users to submit gossip, whether it's true or not, and we'll post it online with some commentary from the person who runs it. This was an allegedly defamatory statement about a Cincinnati Bengals cheerleader, saying that she was sexually promiscuous, that she had sexually transmitted diseases, that she was a teacher at a local high school and had a relationship with a student, which turned out to be the basis of a separate criminal case, which sort of became a circus in this, a sideshow in this case. But ultimately, the Sixth Circuit adopted the material contribution test and found that notwithstanding that this site, didn't post everything, they made some editorial decisions, they made decisions on what exactly to post, they held that was not a material contribution under Section 230, and thus the Dirty World itself was not liable for that content. There was a small bit where the court was willing to hold the Dirty liable for its own commentary. So in other words, when the editor of the Dirty gets online and says, here's this letter we received, if in his summary there he were to have some defamatory or other illegal content, the court was willing to hold that immunity wouldn't stand in that case. But that's not how the case was pled, so ultimately there was no liability. As a result, I pulled this from the Dirty's website last night. This is from their legal frequently asked questions portion of their site. Can I sue the Dirty for publishing false information? In a word, no. Under federal law known as the CDA 230, they're generally not liable for publishing content for third-party users. They're basically advertising that perhaps even if they know it's false, they're nonetheless not liable. Another case out of the First Circuit is Jane Doe versus Backpage, and we're getting into the cases where it's really horrible facts. So things that we really do not want to see happen are nonetheless the intermediaries are nonetheless protected. So this is victims of sex trafficking suing Backpage, saying that Backpage is essentially a site for online pimps. We are selling children for sex, and Backpage enables it. and there's lots of horrible evidence. There's a book written by a professor called Jeff Kosseff called the 26 Words That Created the Internet about the history of Section 230, and really gets into some of the horrible evidence here where the moderators are really saying, remove this word that makes it sound like we're into sex trafficking, but nonetheless wouldn't strike the post. They would let it post, just sort of sanitized so it didn't raise the ears of any regulators. But even that act of selectively removing postings or discouraging, removing postings discouraging sex trafficking or moderating it in that way, nonetheless, the users who posted it were the source of the illegal content, and thus Backpage could not be held liable. The court said showing that a website operates through a meretricious business model is not enough to strip away those protections. Another case that I'll run through quickly is just decided very recently out of the Wisconsin Supreme Court. It was about a website called Arms List that facilitated the purchase and sale of guns. So somebody whose family members were killed in a mass shooting with a gun purchased on this website, the survivors attempted to hold Arms List liable for this sale. And the question is, and really Arms List and roommates are I think, the source of Senator Cruz's confusion about neutral public forum. What these cases talk about are neutral tools. So in roommates, the open-ended narrative portion is a neutral tool. That's not inducing anyone to submit any illegal content in the way that their drop-down menu is. Similarly, Arms List is a forum for legal and apparently illegal gun sales. So that is in terms of the legality of the sale, that is a neutral tool. The Wisconsin Supreme Court said that Section 230 applied to make Arms List immune from suit. Another recent one that was actually cert was just denied in this case. It's called Herrick versus Grindr. Grindr is a gay dating app. Mr. Herrick's ex-boyfriend posted a fake profile, basically soliciting, rough, violent encounters. People were showing up at his home and his workplace, and the theory in Herrick was basically another tort theory where the product was designed in a way that they couldn't prevent this. The Second Circuit nonetheless found that Section 230 applied, and again, the Supreme Court denied to review it. The Supreme Court has not yet reviewed the entire scope of Section 230, so the next time it does it will be the first time. These are some legislative proposals. Again, Professor Danielle Citron is at Boston University. She just got a MacArthur Genius Fellow grant, and she wrote an article with Benjamin Wittes about modifying Section 230, and this article was called "The Internet Will Not Break." So the thing that lots of internet service providers would always say is if you strip this immunity for fear of being held liable for what our users post, we either won't let any users post anything, or it will become such a free-for-all that it will become unusable. They've proposed that along with the Good Samaritan blocking and moderating, that we require that you be a Good Samaritan and we not give this immunity to effectively bad Samaritans. That would be the grinders who don't disable access to this profile. That would be the Arms List who facilitates illegal gun sales. What they call a moderate legislative proposal is they would limit this immunity to sites that take reasonable steps to prevent unlawful uses of its service, and limit the immunity to situations in which the site is actually the publisher, the speaker. So in this case, if you could show that they weren't reasonable in taking steps to prevent unlawful uses, they could be stripped of that immunity. On sort of the other end of the political spectrum, Senator Hawley has introduced the Stop Internet Censorship Act, would essentially require sites to obtain a certification after an external audit from the FTC saying that they do not make politically motivated moderation decisions, and if they didn't receive that certificate, they would not be immune from suit under Section 230. this would apply to only companies with more than 30 million active monthly users, trying to give sort of a nod to the online innovation that Section 230 was designed to protect. Really, if you all remember FCC versus Red Lion, where it was the fairness doctrine case, where they said that broadcast radio, it did not violate the First Amendment to require broadcast audio to allow somebody to respond to something said about them in a political way. This is essentially that case. The argument is that Section 230's grant of immunity was essentially a gift to the tech companies, and in exchange for that gift, they should have some essence of fairness. And back to the other end of the political spectrum, Nancy Pelosi has recently said that tech companies are abusing the immunity they enjoy under the CDA, and it could be in jeopardy, sort of signaling that she may be open to legislation. I don't want to get too much into Lawrence Lessig's 4 modes of regulation. This is from an article called The Law of the Horse, again back in the 90s, and what Professor Lessig was talking about was that on the internet truly is different. So the Law of the Horse was a comment made by Judge Easterbrook of the Seventh Circuit saying we shouldn't study cyber law. Studying cyber law is like studying a course called the Law of the Horse. And the idea was if we've got a contract dispute about a horse, we should deal with that with contract law. If a horse jumps through my window, we should deal with that with tort law. Those types of issues. Professor Lessig was saying that the internet truly is different because of the infrastructure, and what he's really getting at is the law is not the only mode of regulation on the internet. What also matters is the infrastructure, the norms, and the market, and really the ways the internet is built can enable or disable some of this illegal or otherwise troublesome content. In that vein, this is from a recent article by Professor Jack Balkin at Yale Law School entitled Free Speech is a Triangle. And I know this is somewhat complicated, but basically what you have is in your upper left you have governments, in your lower corner you've got end users and other groups, and in the upper right you really have what he's calling new school speech regulations, where governments foist these requirements on infrastructure providers, the social media platforms, the internet service providers, and the like. There's a really interesting article that's on the reverse of your sheet in Wired magazine about a site called really an infrastructure provider called Cloudflare. Cloudflare on the internet, if a website is overwhelmed with requests for information, it's called a denial of service attack, and it's a common way for hackers or otherwise folks to take down content on the internet. It's essentially a heckler's veto on the internet, overloading a site with requests so that the content comes down. Cloudflare prevents those. It screens tests on the way in, and Cloudflare in its beginning saw itself as a truly neutral infrastructure element. The idea being you don't regulate content. It's sort of the net neutrality principle. You don't regulate content at the infrastructure level. You regulate it at the application level, and making those decisions at sort of the infrastructure level would impermissibly in their mind, become sort of a multimodal level of content regulation. For a while, they protected even some extremist sites. There's a site called Stormfront that is home to a lot of white supremacist content. At a certain point, they were the only internet infrastructure provider of any size that was still protecting this site. They decided to stop protecting that site because eventually Stormfront said, these people must like us because they're the only people who are still standing with us. So they became not neutral, and at that point where they saw themselves as not neutral, they decided to exercise their own rights and stop servicing Stormfront. So this all gets into private ordering and really end-user licensing agreements, terms of service, and how speech is regulated online is really, again, driven by these private companies. Facebook has just rolled out, and there's another article on the reverse of that page called The New Governors. You may have heard of or seen the New York Times article about Facebook's Supreme Court. Facebook is trying to be more be more transparent and be more sensitive to its community. But if you review some of their community standards, certainly these are things that would not meet constitutional muster if they were passed by a government. So they regulate cruel and insensitive conduct. So again, that wouldn't pass muster if it were a government passing this. They've also have a new policy on false news, and this is in what made part of this talk so difficult to prepare for is this is coming out day to day. Even Senator Warren was criticizing Facebook for their refusal to moderate false political speech, and Facebook's view on this is essentially, in terms of political speech, we're not going to regulate that. They want a robust political discussion, and they've made this policy choice. And the idea is, again, going to those 4 modes of regulation. If we as users are unhappy with that, we should leave Facebook en masse and not give them the power to make these kinds of decisions. But Section 230 really enables these sites to make their own standards and make their own decisions in a way that will facilitate user content and appeal to their user base. I'll also go to my friend Peter Patakos' official policy on commenting on free speech on his Cleveland sports blog called Cleveland Frowns. I will disclose that I'm of counsel at the Patakos law firm, and we recently won the Cleveland Metropolitan Bar Association Lawyers League Softball League this summer. So I'm not a totally unbiased presenter in this, but certainly Peter views his site and the comments on his site as a dinner party or a problem-solving committee, and it's not perfect, and he will remove what he calls diminishing clutter. And he says it will vary, it's vague. Basically, this is a vague and overbroad regulation that would have serious problems if the government tried to propose something like this. And essentially what he's saying is if there's any doubts, I'm going to delete your comment, and there's nothing you can do to stop me because of this immunity that I have to regulate. And this is a version of sort of that Good Samaritan blocking that is really the essence and the flip side of CDA 230. And finally, I'll get to a mode of regulation on the internet and really a law, the Digital Millennium Copyright Act. And this is intellectual property is specifically excluded from the protection of 230. So if you're infringing intellectual property as a site, you are not going to be held immune for that. The notice and takedown safe harbor under the Digital Millennium Copyright Act basically says if a site takes these steps to protect intellectual property, that is, it takes something down once it gets noticed that something's infringing and allows somebody to respond in the ways it's not infringing, then it will not be held liable as an intermediary for that copyright infringement. If they don't abide by this notice and takedown procedure, then they may be held liable as an intermediary for that copyright infringement, contributory infringement. What we've seen, though, is that, and you'll see my subtitle here is a collateral censorship model. What people say is the Digital Millennium Copyright Act is really the strongest form of censorship on the internet. So if you want something removed from the internet that's defamatory, the slow way is to go to a court and allege defamation and to send a subpoena to Twitter or Facebook or somebody and try to get the identity of an anonymous user under the Digital Millennium Copyright Act. And this actually happened with Ellen recently regarding her attending a sports event with George W. Bush. Somebody put a picture, or really a slideshow of Abu Ghraib behind her talking about how horrible George Bush was, and then sort of juxtaposed that with her sitting at this game with him. Somebody got that internet got that video off of the internet in a matter of hours. So really, if we were to look at defamation claims and a way of legislating a notice and takedown procedure for defamation or other illegal content in order to give intermediaries this immunity, I think what you would see is a lot of wrongful takedowns and really abuse of the system. I won't play John Perry Barlow for you again, but again, you can find the Declaration of the Freedom of Cyberspace out there on the internet. Happy to take any questions if there are any. If not, I really appreciate you all sitting here with me. I hope we've learned something. I hope we've accurately described it. I hope when you hear folks say that you need to be a neutral public forum in order to be entitled to the immunity under Section 230, we now all have the tools to tell them why that's wrong.
For anyone who has questions, if they want to raise their hand, we're webcasting this, so in order to pick up your questions, you'd have to speak it into microphone, so I can bring the microphone around for anyone who has a question.
So this would have protected that woman a half hour ago that began with Z, that where they put the wrong stuff and it wasn't her or him.
The Digital Millennium Copyright Act. Well, if the Digital Millennium Copyright Act institutes a legal process, so it says, I'm the owner of the copyright in some of this information, you've got to take it down off of the internet. So that person would have had to make a claim to that ad that was posted, and really you don't have copyright protection in your name. It would really be sort of a privacy tort that they would be going after. So there are penalties for wrongful takedowns under the Digital Millennium Copyright Act, but it's not something you see a lot. And in fact, when we draft policies for my clients who have websites and say they will abide by this notice and takedown in order for them to be entitled to this immunity, what we say is when you send a takedown notice, know that you're instituting a legal process and it's potentially sanctionable if you do it in a frivolous way. All right, well, thank you all for coming. Thanks.